This is going to be about several influential Supreme Court decisions. So I'm poking around doing some reading on the general subject of the Supreme Court, Scotus, as it's known. And I started with a book called Supreme Power, a study of 7 decisions that the author, himself a judge, thinks had a major impact on the nation and the influence of that august body of 9. With power, you either use it or you lose it, and it goes against human nature to lose power. So the court uses it, and when you use power, you tend to increase it. I'm not saying, and the author isn't either, that the Supreme Court has staged a calculated, systematic power grab. Most of what has occurred was done either reluctantly or inadvertently, leading to a largely unforeseen result: more power. Take the first case, Marbury versus Madison. Marbury had been given a signed commission by then-President John Adams to be a Justice of the Peace, a very good position then. But that commission had not been delivered, and Adams was no longer in office, so Marbury sued to get that commission. Chief Justice John Marshall ruled that he had a right to that commission, and that there was a legal way for him to get it, that a court could issue a writ of mandamus ordering Secretary of State Madison to deliver the commission. But he also concluded that the Supreme Court had no jurisdiction in the case and could not issue the writ. It seems that Marshall is acknowledging a limit to the power of the court, but in doing so, he was also declaring that an existing law, the Judicial Act of 1789, was unconstitutional. The court's ability, first recognized here, to declare what is a law and what is not, is called judicial review. Marshall never employed it again, and the court didn't use it again until 1857 in the Dred Scott case. But from 1865 to 1898, 21 acts of Congress were found to be in a violation of the Constitution, and so, under judicial review, were voided. That's power. The author clearly shows how the court increased its already considerable influence in the 6 other decisions. In Plessy versus Ferguson, 1896, there was a case that had been fashioned to kill the practice of separate but equal in its infancy, specifically in reference to railroad cars. But that backfired when the court found that the railroad had a right to run its business as it pleased, so long as separate was equal. And, as the author noted, within 20 years of 1900, blacks disappeared from rail cars, streetcars, steamboats, the voting booth, public office, juries, judgeships, city councils, and Congress, all traceable to that one Supreme Court ruling. In Lochner versus the State of New York, 1905, a case about the number of hours a baker could work, the court extended its reach beyond due process of law to something it identified as substantive due process, redefining the concept of individual liberty and acting not by existing law, but by what 5 judges thought was right. That led directly to the court's ruling in Roe versus Wade. In 1942, Wickard versus Fiburn, a case involving 12 acres of wheat, the court used its influence over the powers of commerce to legally regulate not just transportation, but also production, stripping that power from the states. In Emerson versus the Board of Education of Ewing Township, 1947, the court refused to rule in favor of religion, any religion, citing the protection of the First Amendment, claiming, after a letter by Jefferson, that there was a wall between church and state, and that removed religion from most public associations, prayer in schools, Bibles in courthouses, etc. In 1990, Missouri versus Jenkins, the court backed a judge determined to redress the evils of slavery, Jim Crow, and segregation in a massive $2 billion plan to rebuild the Kansas City School District, paid for by 2 taxes enforced by the judge. The ability of the judiciary to set policy and tax was new and well-intentioned, but the plan was a complete colossal failure both for education and integration, and maybe law as well. Finally, 2015, Obergefell versus Hodges, the court discovered what it called penumbras and emanations in the Bill of Rights that led to an even sharper focus on personal liberty from Lochner, to individual autonomy, self-definition, and dignity all become legal individual rights. The court had become an agent for social change. The author calls all of this a soft tyranny. I think it's more the classic warm and fuzzy. It's nice. Be nice. The progressive mandate has always been to make the world a better place, more tolerant. Who could disagree with that? Recent rulings of the court make it binding that we tolerate everything. Discrimination of any kind, including good from bad, right from wrong, wheat from chaff, is wrong. So make nice, legally.